pleased to have you all here today. I want to introduce our speaker right away. Dick Crabtree is going to talk to you today about estate planning and wills and all the things that you need to know. Dick is a retired Air Force officer who spent his entire career as a special agent with the Air Force Office of Special Investigations, OSI. Dick went to law school after he retired from the Air Force and became an elder law and estate planning attorney. He practiced in Colorado. Dick and Kathy have lived at the Ark for 4 years, moving here from their home state of Colorado. And with that brief introduction, we'll get right to it. Here comes Dick.
Good morning, everybody. Can you hear me okay?
Yes.
Thanks for being here this morning to learn a little bit about advance directives and why I think they're so important as you move through the continuum of care, not only for you, but for your family members. Resident Services has blank copies of these various forms I'm talking about today. So if you don't have any of these documents and you want to get them after today's presentation, talk to Lori or Debbie or Kathy in Resident Services. So what I want to do is discuss these directives as in a timeline as you go through your life. And I'll try to have you out of here under 4 hours today. Some of you already have some or all of these documents that I'm going to talk about today, and that is great. However, some of you and your neighbors and friends at the Ark may not have the documents or appreciate the importance of having them. What I want to do then is talk about these and tell you the reasons why I think everyone in this room should have them. Again, not only for your sake, but for your family's sake and peace of mind also. Some of you may be thinking that you don't need any of these documents right now because you're relatively healthy, you can still get around, you can make it to happy hour, you can make it to the Blue Bonnet or Water's Edge. You're mentally and physically alert. You can still make your own financial decisions. And you really don't want to think about death or dying because it's too depressing. But what happens if you don't have these documents and when you leave here this morning you fall on the sidewalk and hit your head, become unconscious, and in the process you also break your hip? So you're rushed to Methodist Hospital or BAMC. Who's going to take care of the paperwork to get you admitted? Who's going to consent to the medical treatment you need? After you leave the hospital, who will take care of the arrangements to transfer you to health care here at the Ark or a rehab facility? While on health care, decisions need to be made about your treatment plan and your medications. Who, for example, is going to contact your local doctor and request a prescription? So what I want to do this morning is go through the various documents as you progress through the continuum of care, beginning with the durable power of attorney, also known as a financial power of attorney, then the medical power of attorney, then the advance directive or living will, and then after you pass away, your burial instructions, and finally talk about your will or trust. Before we get started, I have good news and bad news. The bad news is that I'm not licensed to practice law in Texas, only in Colorado. What that means is that I cannot give you specific legal advice or guidance about any Texas law, any issue that you may have individually. The good news is, because I can't give you specific legal advice, I won't be sending you a bill this morning for my presentation. So, having said that, I'll be glad to answer any questions you might have at the end of the presentation. And at the end, before the questions, I've asked Linda Sorber, fellow Ark resident, to come up and talk to you a little bit about the various types of charitable trusts that exist, and give you information that may be helpful in that regard. So the first document is the financial power of attorney. And like Noah, we're all going to have a flood at some point in our lives. And it is better to be prepared than not. A financial power of attorney is a document where you, the principal, choose a person called the agent to handle your financial and other daily activities and transactions if you can't do them for yourself for some reason. An agent is simply the person you name to act for you if you are unable to act for yourself, and occasionally you'll see this term agent in fact, and it's just a fancy term meaning agent. A financial power of attorney is a very powerful document and can be disastrous in the wrong hands. You've probably read or seen on TV news stories about a family member or a trusted attorney who have misused the document to steal from the principal. To avoid that happening, it's very important for you to choose someone who's totally honest and trustworthy as your agent. Sometimes I see a family dynamic where there are two children. The oldest is a son who just got out of prison for selling narcotics and embezzlement. The younger child is a daughter who's a certified public accountant and a deacon in her church. The parent is torn in naming his or her agent because he or she feels that the son, being the oldest, should be the agent. That's a bad choice, bad choice. So choose the person who is not going to clean out your bank accounts and sell your house. Next, choose someone to be the successor agent in the event that your primary agent is unable or unwilling to serve for whatever reason. Use the same criteria in choosing the successor agent that you used in choosing your primary agent. Here's some practical reasons why you need a financial power of attorney. A lot of ARC residents like to go on cruises, sometimes for weeks or months at a time. So what happens when you're in your second month of your 4-month cruise and a bunch of things start happening back here at the ARC? For example, you get a notice that your bank or credit union somehow messed up your automatic monthly maintenance payment to the ARC, or your car registration needs to be renewed, or you get a Bexar County jury summons in the mail requiring you to respond in 7 days, or you get a letter from the IRS saying they are auditing your 2023 tax return and you need to come in for a personal interview next week. If you have a financial power of attorney, your agent can take care of all of those things for you while you have another martini on the sun deck. Finally, before we move on to the medical power of attorney, it's important that you realize what to do with these documents, and this covers all of them. I always recommend that you make copies of the documents once you have them. Never give the original to anybody. Just give a doctor, for example, a copy of your document. And occasionally you'll find a healthcare provider that'll insist on an original, and just tell them, no, you really don't need the original, here's a copy, and that's good enough. So the medical power of attorney works the exact same way as a financial power of attorney. You name an agent to make all of your healthcare decisions and take actions on your behalf if you're unable to do so. You also need to select a successor agent, just as with the financial power of attorney. The selection of an agent in a medical power of attorney is probably even more critical than the agent in a financial power of attorney, because that person will potentially have to make life or death decisions for you. It is vitally important that you sit down with your agent and discuss your wishes, exactly what you would want or not want as far as treatment. if you're unable to communicate those when the time comes. Keep in mind that the powers of attorney we're talking about today only come into play if you are unable or unavailable to make your own decisions and take the actions necessary for your life. In a medical power of attorney, you can specify the treatments that you want or do not want. For example, if you have if you're in stage 3 or 4 cancer, you can tell the doctors that you do not want chemo or radiation, or conversely that you do want those things. If you have breast cancer, you can tell the doctor that you want a mastectomy or you don't want a mastectomy. There are other things you can do in a medical power of attorney, but it's important that your agent knows exactly what you want and what you don't want. If you're in a condition where the doctors say, well, you may have to be hooked up to a ventilator or have a breathing or feeding tube inserted, you can say in your medical power of attorney that yes, you would want that, or no, you wouldn't. You can say that you may not want blood transfusions because of religious reasons. Your agent needs to know exactly what it is you want and don't want, and be willing to carry out those wishes, even if that isn't the decision that the agent would have made otherwise. In other words, make sure your agent is on the same sheet of music as you about your health care. One document that I'm not going to spend too much time on this morning is the HIPAA release. HIPAA stands for the Health Insurance Portability and Accountability Act, which was a law enacted by Congress in 1996. This is the Federal Privacy Act that protects a patient's privacy and forbids healthcare providers from releasing information about a patient without that patient's permission. In my practice, I advise my clients to use the HIPAA release in conjunction with their medical power of attorney. You can name your agent in your medical power of attorney as your representative in the HIPAA release as the person to receive your health care information. You'll find that some medical providers follow HIPAA more closely than others, depending on how fearful their lawyers have made them about being sued for violating HIPAA. I had a client whose sister lived in Minneapolis, and my client was in Colorado. My client received a phone call one day from her sister's neighbor that the sister had been taken to a hospital in Minneapolis. So my client called the hospital, and because of HIPAA, the hospital wouldn't even acknowledge that her sister was a patient. They absolutely refused to give her any information. So my client called me and said, can you help me? And I ended up calling the hospital administrator, convinced him to talk to the charge nurse and talk to my client. Well, by the time all this got resolved, the sister passed away before my client ever had a chance to tell her sister goodbye. So you just want to be aware of the fact that you can't assume that because you're a spouse or a parent, son or daughter, that a medical provider is going to give you information about your loved one without a HIPAA release. So keep that in mind, and it's a good document to have. Another document that I'm not going to spend much time on this morning is the Do Not Resuscitate Order, the DNR. The reason is that attorneys cannot prepare DNRs. Only doctors can do that. My son sent me an article last night out of the Washington Post, very timely. It talked about the pitfalls of DNR. And it talked about 3 individuals in the Washington, D.C. area who had DNRs, but they weren't honored for whatever reason. Either the doctor couldn't find it in the chart, or for whatever reason they ignored it. And this article described how things can go terribly wrong when the DNR is in is in existence, but it's not followed. Patients suffered broken ribs and other internal injuries because of the extraordinary measures taken. One had a feeding tube because they just couldn't breathe after the procedure. And so just because you have a DNR, like most of these documents, hopefully everything will turn out right, but you just can't make that assumption sometimes. The next slide, as you go through the continuum of care, is the directive to physicians or living will. This is the document that allows you to decide in advance if you wish to have artificial measures taken to keep you alive when you are near death. There is no agent in this document like the other two powers of attorney. This is your document and yours alone. This document tells the doctors what to do if you have either a terminal condition from which you are expected to die within 6 months, even with life-sustaining treatment provided in accordance with prevailing standards of medical care, or you're in an irreversible condition that you cannot care for yourself or make decisions for yourself, and you're expected to die without life-sustaining treatment. If either one or both of these situations exist, this document tells the doctors what you want to happen. Either be kept alive using all available life-sustaining treatments, such as ventilator, respirator, feeding tubes, or have all that stopped and that you die comfortably. So this is a document that is the last document that you use while you're alive. Now we'll talk about what happens after you pass away. First document that your survivors need is a burial instruction. And this document is simply a document that tells your survivors that you want to be buried and where, or cremated, and the disposition of your cremated remains. In this document, you can also include some details regarding your funeral or memorial service, such as the pallbearers, music, spiritual scripture readings, etc. I recommend that you put such details in your burial instructions rather than in your will, which we will discuss next. Because if your will is lost or can't be quickly found, your funeral or memorial service could be delayed. Okay, moving through the continuum. So now you're a permanent resident of Fort Sam Cemetery. Now what? That is when your will or trust or both come into play. As I said earlier, powers of attorney cannot be used after you die. The agents in those documents no longer have any legal authority to act on your behalf. A will is basically a document, simply a document that takes effect when you die and says who gets your stuff. And that stuff is called your estate. Living in Texas, your estate could include a condo down at Port A, cattle ranch out in Uvalde, mineral rights up in Midland, rental property in Garden Ridge, or your prized possessions, including your 1958 Edsel. If you're an art collector, it could be a painting of Elvis on velvet. Could be dogs playing poker. Or if you're a music collector, it could be your very valuable collection of Lawrence Welk 8-track tapes or stereo records. All that is considered stuff, and stuff is your estate. I want to talk about what happens if you have a will. You think everything's perfect and your wishes are going to be carried out. Well, here's a case where Princess Diana initially did everything right. She had a will that left $70,000 to her butler, sentimental belongings such as photos, paintings, and china to her 17 godchildren, and the rest of her estate to William and Harry. Meghan wasn't in the picture yet. So far, so good. However, later a handwritten letter of wishes was found that requested that all of her jewelry and 3/4 of her personal belongings be passed to William and Harry, and 1/4 to her 17 godchildren to be divided equally. There was a will contest by the parents of the godchildren since the two documents were inconsistent. The letter of wishes was thrown out by a London court because it hadn't been executed in accordance with British law. So as a result, each of the 17 godchildren only received one item from Diana's collection of personal property instead of the 1/4 of her personal property valued at $160,000. The first lesson from Diana's case is to make sure your estate planning documents are consistent. One of the surest ways to bring about a will contest in court is to have inconsistent documents. The second lesson to be learned from her case is to make sure your documents are prepared so that they meet all legal requirements. Each state has different witness and notary requirements for wills, trust, and other advanced directives. If Diana had an attorney prepare a codicil to her will, which is just a legally enforceable amendment to the will, her estate would have been distributed according to her wishes. Never make your own pen and ink changes to your documents or write new things in the margins, because if you do, you could invalidate those documents just like Diana did with her letter of wishes. Probate is simply the process by which a court validates a will and officially appoints a person called the executor to administer your will. The executor makes sure your estate stuff gets distributed according to the terms of your will. Not all of your stuff has to go through probate. Only those assets that you own as an individual need to be probated. Any jointly owned asset, such as a house, a joint tenancy, motor vehicle with two people on the title, those types of assets, if there's a joint owner, they do not need to be probated. Bank accounts, payable on death accounts, those types of things do not need to be probated because the asset automatically goes to the surviving joint owner. Likewise, any asset with a beneficiary designation, such as a life insurance policy or an IRA or an annuity, will pass directly to the named beneficiary without going through probate. So why do we need probate? It becomes necessary if a person dies owning an asset, such as land, house, ranch, bank account, brokerage account, etc., with no co-owner. Since the owner is dead, there's no one who can sign deeds or contracts to transfer those assets according to the terms of the will. A probate court simply appoints the person named in the will as executor to do those things. So once the executor is appointed, they gather all the assets, they pay all the claims against the estate, they distribute the assets according to the terms of the will, and they wrap up whatever the court says needs to be taken care of to close out the estate. Here's an example of a man who, it gives you an idea what can go wrong in probate. As it says, Howard Hughes wanted to give his $42.5 billion estate for medical research. There was only one problem, however. He didn't have a will or a trust. So after 34 years of court battles, his fortune was divided amongst his 25 cousins, contrary to his wishes. Took 34 years in court to finally get everything resolved. So, and after your death, there are documents that come into play besides a will. Trust is one of the documents next to a will that you can use to manage your affairs both before you die and after you die. A trust is basically a contract between three people to hold, manage, and distribute your assets. The grantor, or sometimes called settlor, is the person who creates the trust. The trustee is the person named by the grantor to administer the trust and distributing your assets to the person named in the trust, and that person or person is called the beneficiary. One person can fill all three of these roles, or there can be three separate individuals in each. A trustee is similar to an executor in a will, but a trustee can act during your lifetime and after you die, whereas an executor can only act after you die, because that is when your will takes effect. There are many different types of trust. The three that I'm going to talk about this morning are the most, I found, are most common in my practice, because my clientele in Colorado were mostly blue-collar, working-class folks, small business owners, small farmers. They didn't have really large estates where they had to consider charitable giving. So these are the three trusts that I dealt with mostly in my practice. As I said at the end, Linda's going to come up and tell you a little bit about charitable trust. But the three types that I dealt with mostly are the irrevocable living trust, the irrevocable trust, and the testamentary trust. A irrevocable living trust is a trust created by you, the grantor, during your lifetime, and it allows you to change or dissolve the trust. It also allows you to add or delete assets to or from the trust. As you acquire something or you decide to sell something, you can change the schedule in the trust that lists your assets, and you can make those changes. An irrevocable trust is a trust where the grantor does not have the right or power to change or dissolve the trust or add or delete assets to the trust. There have been some recent changes in law, particularly here in Texas, where there is a way now that you can change an irrevocable trust, but it's very time-consuming and expensive, and basically you're stuck with what the trust says when you executed it. Testamentary trust. It's a trust that's created inside of a will and doesn't become effective until you die and your will comes into play. An example of a testamentary trust would be where you give money to your grandchildren who are minors and cannot receive the money directly. You can create a trust in your will that says a trustee shall hold the money for the grandkids until they become adults, at which time they shall receive their inheritance. You can put terms on the distribution, such as my granddaughter Jane shall receive half of my estate when she reaches 25 years of age, provided she has received a bachelor's degree from an accredited college or university, and the balance of my estate when she reaches 30 years of age. The trustee can be the person named as executor of your will, or a different person. Some of my clients like that division of responsibility because it provided a check and balance on the distribution of the inheritance assets. In addition to these three main types of trust, there are many other trusts, so many in fact that I've spent hours in mind-numbing continuing legal education seminars back in Colorado, learning about all these trusts. There's protection trust, asset protection trust, there's a crummy trust, which is named after a court case that allows you to distribute assets to beneficiaries, usually grandkids, over a long period of time. And as I said, there are various types of charitable trust. There are special needs trusts that allow you to make special provision for a disabled child or adult that allows that child or adult to continue to receive their government benefits if they receive an inheritance that would otherwise put them above the income or asset level that would cause them to lose those benefits. And finally, there's a pet trust. All you dog and cat lovers in here and other animal lovers, yes, you can set up a pet trust for your pets. An example would be a testimony pet trust in your will where you leave $50,000 to your dog Charlie to be held in trust by your trustee for Charlie's care until he dies. A word of warning, however, that you may receive some blowback with such a trust. I prepared a pet trust one time for a client, leaving $50,000 to my client's dog, while leaving only $25,000 to a nephew in her will. The nephew was very angry and asked my client why she gave him less money than her dog. My client answered that she liked her dog better than her nephew. There's pros and cons of wills and trusts. Wills are cheaper than trusts usually and require less work and attention. Wills carry out your wishes, not the state of Texas, if you don't have a will. Trusts may avoid probate, however, there are disadvantages. One of the biggest disadvantages of a trust is that it needs to be funded. That means for the trust to operate, it needs to have assets transferred into it. A house or land needs to be retitled in the name of the trust. Sometimes that causes big problems if there's a mortgage on the property, because the mortgage company may call in the note for full payment when it learns the title of the property was changed in violation of the terms. Bank accounts, brokerage accounts, annuities, all need to be retitled from Jane Doe as an individual to the Jane Doe Revocable Trust. Many people opt for a trust over a will because they want to avoid probate. However, they fail to fund their trust with their assets, and those assets have to go through probate anyway, because there is no other way to transfer them. One person who learned the hard way about failing to fund a trust was this gentleman. Michael Jackson died in 2009. He planned ahead and created a trust in 1995, which he amended in 2002 to protect his massive estate for the benefit of his 3 minor children and his mother. However, he failed to fund the trust and did not retitle any of his multi-million-dollar assets, including Neverland, into the trust. He left his entire estate out of the trust, and his estate had to go through probate, which he wanted to avoid. Since his death in 2019, his estate has been tied up in litigation with the IRS over the value of his assets. In 2021, the IRS claimed that his estate undervalued his assets and thus owed an additional $700 million in taxes and penalties. Due to the unresolved tax issues, none of Jackson's 3 children or his mother have received their inheritances. To make matters worse, his mother instituted a separate legal action challenging some of the actions that the executor had taken. As recently as this May, 15 years after his death, the litigation is still going on in a California court to resolve Jackson's estate problems. Tony Bennett died last year at age 96. He had a trust and named his oldest son Danny as trustee of the Tony Bennett Trust. Unlike Michael Jackson, Bennett funded his trust, so it was fully operational and legally operable when he died. Bennett did everything right. Unfortunately, family dynamics intervened, and two of Bennett's daughters are suing their brother, whom they allege mishandled and failed to disclose some of their father's assets in his sole role as trustee of the trust. This litigation could drag on for months or years. And guess who wins in the end? The lawyers. Tony's case emphasizes the sad truth that you can only control so much from beyond the grave. You can plan ahead, you can have all the advanced directives we were talking about today, and think you've done everything humanly possible to make things easier for your survivors when you die. However, if you have a dysfunctional family, disputes are going to arise and all of your planning goes out the window. Even if you think your family dynamic is perfect, it may not be. In my practice, I witnessed how death can do really weird and strange things to survivors. On one occasion, my deceased client was being lowered into the ground at the graveside service when her two children, both in their 60s, got into a fist fight because decades of anger and hatred between the son and daughter came to the surface. Apparently it had started 50 years earlier when the son pulled his sister's ponytail and she shoved him down some stairs. They never got over it. But anyway, I digress. Jay Leno and his wife learned the hard way about having powers of attorney. Neither had any powers of attorney, so when Mavis became incapacitated due to dementia earlier this year and could no longer handle her financial affairs, Jay had to go into a California court and petition the court to appoint him as conservator of his wife's estate. Jay wanted to create a trust for Mavis in her name to hold assets that Jay would provide as trustee for her care until her death, as well as for her brother, who is her only sole living heir aside from Jay. It took months for the court to act. All this would have been unnecessary if Mavis had had a financial and medical power of attorney, naming Jay as her agent. He could have acted on her behalf. So without these, they're in court. It's still going on. It's extremely expensive for a conservatorship or guardianship procedure. And another family in Hollywood learned the hard way of failing to plan ahead and have advanced directives. Earlier this year, in another California court, a conservatorship was established for Brian Wilson, one of the original Beach Boys, age 81, following the death of his wife who had cared for him as Wilson struggled with a major neurocognitive disorder. Wilson's manager and his publicist were appointed as conservators by the court. When the court found, and I quote, that there was clear convincing evidence that the conservatorship was necessary and appropriate because Mr. Wilson was unable to care for himself and lacked the capacity to make decisions about his own health and medication. Once again, poor estate planning on the part of Brian Wilson and his family and attorneys led to the disastrous situation. If only he had a financial and medical power of attorney in place, this conservatorship court proceeding would have been unnecessary. Before I move on to the next example, what can go wrong even when you plan ahead, I want to share some statistics I found doing research for this presentation. Only 1 in 9 Americans, get back up here. This mouse is very sensitive. 1 in 9 Americans aged 65 or older are among the 6.7 million people in the United States with Alzheimer's. Last year, the lifetime cost of care for a person living with dementia was $392,874. All the more reason to plan ahead and have advance directives in place before you need them. In April 2022, Bruce Willis was diagnosed with aphasia, which the nurses in the audience know is a language disorder caused by damage to the area of the brain responsible for expression and comprehension. By last year, Willis's condition had progressed considerably, and he was diagnosed with frontal temporal dementia. Even with this time frame and time to do things and get, set up and plan ahead, he didn't have any of the documents needed. So his family's in a California court also getting a conservatorship and guardianship for Bruce Willis. Last two cases are the most egregious and tragic that can happen if you don't plan ahead, or even if you do, things can go wrong because of the family situation. Casey Kasem, remember America's Top 40? He died in 2014. He had planned ahead and had a financial power of attorney, a medical power of attorney, and a living will. He established a medical power of attorney in 2007, naming his daughter Carrie Kasem from his first marriage as his agent. A dispute arose when the second wife, Jean, moved Casey from a nursing home in California to Washington State without notifying his children. His second wife, Jean, moved Casey from a nursing home in California to Washington State, and she didn't bother to tell his children what she was doing. The case also involved, you can take that. Case also, I'll have my mouse figured out by time if you want. The case also involved questions about Casey's mental capacity and whether he had been forced by Jean into making changes to his estate plan while suffering from dementia. These allegations caused severe tensions between Jean and Casey's children from his first marriage, and allegations that Casey suffered from neglect and abuse at the hands of Jean. Finally, the complexity of the situation escalated even further when Jean basically kidnapped Casey's corpse from a funeral home in Washington and took it to Montreal and then on to Norway, where he was buried more than 6 months after his death. His daughter and his other two children produced documents from Casey saying that he wanted to be buried in Forest Lawn Cemetery in Glendale, California. Casey had no connection to Norway. He was Lebanese and had never been to Norway. His daughter believes Jean buried Casey in Norway to avoid being charged and prosecuted for elder abuse in Santa Monica. It came to light that Casey's medical power of attorney and living will may not have been followed during his terminal illness. It took years of litigation between Casey's second wife and his children from his first marriage to resolve all the issues surrounding mental capacity, undue influence, abuse, and neglect. A criminal investigation found no evidence of criminal wrongdoing. Nevertheless, Casey's case study emphasizes the importance of establishing powers of attorney, while one still has the legal capacity to do so. Individuals who understand your wishes and can act on them need to know in advance that what those are and that you have the documents. I've saved the most egregious example of what can happen when you fail to plan ahead as you move through the continuum of care. I'll let Mickey tell you himself.
In 2009, 1 in 7 older Americans was abused, according to a government study. On Wednesday, a Senate committee heard from a Hollywood legend who says he is one of those victims. CBS News congressional correspondent Nancy Cordes is on Capitol Hill this morning with the story. Nancy, good morning.
Erica, good morning to you. Mickey Rooney was one of the biggest names in movies for decades, and his message to Congress was, if abuse could happen to him, it could happen to any senior.
I felt trapped, scared, and frustrated.
The 90-year-old veteran of the silver screen told lawmakers he was the victim of elder abuse for years before coming forward last month.
Even when I tried to speak up, I was told to shut up.
Dance the whole night through. Good morning to you.
Rooney's dancing and singing and effervescent characters delighted viewers for decades. He made more than 200 movies. But in February, the frail Californian obtained a temporary restraining order against his 52-year-old stepson, complaining that the son of his 8th and current wife had, quote, taken control of Mickey's personal and financial affairs and was verbally abusive, depriving him of medicine and food, even confiscating his identification to prevent him from traveling.
I was eventually and completely stripped of the ability to make even the most basic decisions.
His stepson denies the allegations, but Rooney's story is far from unique.
I am here today because it's so important that I share my story with others.
It's estimated that between 700,000 and 3.5 million older Americans are abused, neglected, or exploited each year, and that only 1 in 6 cases are reported.
Were you glad that you had a chance to share your story?
Everything you heard me say today was real.
And he hopes other seniors will not wait as long as he did to get help.
Rooney says his abusers even took away his Oscar and his Emmy. He says he eventually became practically a prisoner in his own home, Erica.
It's just awful to think about. What are lawmakers actually hoping to achieve? Why are they holding these hearings?
Well, they're looking at possibly reintroducing legislation that would beef up penalties for elder abuse. But what they said their immediate goal is just to shine a light on this problem so that victims or people who see it happening will step forward.
The picture that Mickey Rooney paints when he says that basically everything was taken away from him, did he confide in someone at some point before this?
He didn't, Erica. He said he was, first of all, embarrassed that this had happened to him. He also said that he was afraid that he might be hurt, that his wife might be hurt, and that kept him from coming forward long after he realized that something serious was going on.
Well, it certainly makes you think twice, doesn't it? Nancy Cordes on Capitol Hill this morning. Thanks.
All right. Hate to end on such a sad and tragic note, but that's what happens in our world. This spring and up till now, I think we had 3 different presentations here in the auditorium about elder abuse, fraud on the elderly. Broadway Bank presented a presentation. San Antonio Police came out with 2 detectives to talk about it. And then we had a hospice nurse discussing the cases that she's seen of her patients, primarily and sadly, most of the cases involve family members. So it's real, exists, and we need to be aware of it. So these are the directives we talked about today, why I think they're important. The 2 powers of attorney, the living will, the burial instructions, DNR, HIPAA release, wills, trust, we talked about the probate process, and I showed you some case studies of things that can go drastically wrong, even if you do the planning. So it's no guarantee, but I would strongly suggest that you opt for the positive outcome and have these documents. It'll be a great relief for you and your family members, because they don't have to figure out or try to guess what it is that mom or dad would want when mom and dad are in a position where they can no longer tell the kids or grandkids what it is they would want. So the next few minutes, we're going to have Linda Sorber come up and talk to us about some charitable trusts. Linda?
Okay, the first thing I want to say is I am an attorney licensed in the state of Texas as well as Pennsylvania and Maryland. However, I am not your attorney, nor do I wish to be that. So if anything I say today has particular import for you, please seek your own legal advice. The next thing I want to talk about is our friend the tax man. I want to avoid him at all as much as possible. I don't mind paying my fair share, but I want to avoid overpaying. There are ways of making charitable gifts so that you can avoid tax consequences and in fact lower your taxes. For example, if I have a choice, and I'm going to throw out some numbers just for ease, not because they apply to me or you. If I have $100,000 in the bank and I have $100,000 of stock, maybe an Apple that I maybe paid $10,000 for a long time ago, and I want to give away $100,000 to a charitable institution, it is to my tax advantage to give away the highly appreciated asset because my tax deduction is based upon the fair market value of the asset at the time of the gift. So I get the full $100,000 tax deduction, and it hasn't really cost me anything, and the charity doesn't have to pay taxes on the $90,000 increase. So it's always tax advantageous to give away a highly appreciated asset, if you have one, as opposed to the equivalent in actual cash. Now, there are deductibility limits on the amount that you can give. Again, this may or may not apply to you. For a public charity, that's a 501c3 charity like the ARC, or a 170B1, which would be like an agency of the state like the University of Texas or Texas A&M. In cash, you can give up to 70% of your adjusted gross income in any 1 year. I hope you're in that situation that you're able to do that. If it's an asset that's appreciated, like a stock or a piece of land, then the limit is 30% of your adjusted gross income. Again, I hope you're in that situation. One of the best tax-deferred ways of giving is if you have a tax-deferred IRA, and you can make what is called a QCD, a qualified charitable distribution. Personally, I do this with the ARC. Right, Anna? Where's Anna? Yay. Okay, I'm going to now talk about two types of trusts, the CRAT and the CRUT. One other thing on taxes. The estate tax now doesn't kick in until your estate is $13.61 million. I hope that applies to you, but probably not. If it does apply to you, please go see Hannah. She'd love to talk to you. All right, CRATs and CRUTs. They're both trusts. They're both irrevocable. Once you do it, once you sign that paper, it's done, over, finis, forget about changing it. The charitable remainder annuity trust has a charity, a remainder, that's what's left after the annuitant, and it's a trust. It pays the annuitant a set percentage, generally 5-6%. It could go up to 50, but charities don't like that because it's going to take too much of the trust assets to pay the annuitant. There is a tax deduction based upon the fair market value at the time of inception of what is put into the trust. The donor who is going to receive the annuity is going to have to pay income taxes on the annuity amount. So you're going to get a tax deduction over here, but you're going to pay income taxes over here. Upon the death of the beneficiary or beneficiaries, this can be if you're husband and wife, a 2 lifetime situation, then the remainder goes to the charity. The ARC, the University of Texas, whatever the Red Cross, whatever your favorite charity happens to be. The tax deduction is based upon the amount put into the trust and the age of the annuitants. Obviously, if a 94-year-old establishes one of these, despite the fact that as we age, our life expectancy in fact goes up, the tax deduction is going to be rather larger than if it's done by someone who's 50 years old, because you're expected to live quite a long time that the trust is going to be paying money out to you. The other type of trust is called the charitable remainder unitrust. One of the principal differences between a CRAT and CRUT is that you can make additional gifts into the trust with a unitrust. With an annuity trust, that's it. It's going to pay you 5%. You can't add into it to maybe bump up the value. What you get with the annuity is going to be 5% of the initial fair market value. That trust goes up in value, you're getting 5% of the initial amount. You're not getting 5% of the increase in value. Who's going to get the benefit of the increase? The charity, the remainder. With the unitrust, you're going to get the benefit of the increase in value. This is really important now because of the rise in the stock market and real estate and just about everything else. And with the unitrust, the assets are revalued annually. So if you're going to get 5% in a unitrust, if the value of the land or the stock market has gone up significantly, you're getting 5% of an increased basis. So that generally, you can see that unitrusts are preferred by donors rather than the annuity trust. There's no capital gains tax when you fund one of these things with highly appreciated assets, like stocks or land. So you don't have to worry about that. Of course, if you leave the stocks or land to a beneficiary in the will, they take the value at the time of your death as their basis, so they're not going to pay a capital gains tax either. But however, it's no longer part of your estate, so you're not, if you were going to be subject to the estate tax, it won't be that anymore. But the disadvantage is it's irrevocable and you do lose control. Now there's one other type of trust that is just the reverse of those. It's called the charitable lead trust, in which the charity gets the income for a set period of time or the donor's life, and then the remainder goes back to the donor or his heirs. This is used frequently with very, very large estates where the family doesn't wish to give up the goodies. They're wealthy enough to provide for themselves during the settler's lifetime, but they want the goodies when the settler dies. So again, these are used in very, very large estates. The donor gets the remainder, the charity gets the life income. There are two other kinds of funds, the pooled income fund and donor advised funds. The pooled income fund is all of us get together, create the pool, everybody, the fund makes money. you get a percentage back based upon your percentage of what you put into the fund. That's great, but your percentage goes down as more people get into the pool, unless you keep adding to the pool, which you can. But some institutions do operate a pooled income fund. The income is taxable to you. You're not going to get any charitable donation unless it's a charity that's operating the pooled income fund. And then there are what's called donor advised funds. These can be charitable donations, you get the tax deduction, but the donor reserves the right to advise the charity on how the fund should be used, as opposed to setting up irrevocable guidelines. Now, personal experience from UT Austin, deans of colleges don't like your advice. They think they know how to run their business and they don't need you sticking your nose in. So they're not well advised, but they can exist, so there you have it. And TTG, time to go.
Thank you, Linda, appreciate that. Be glad to answer any questions that you may have, and we'll have a mic here that somebody's going to walk around if you have a question. If not, I appreciate everybody coming this morning and bearing with me with all my technical problems up here. Maybe tomorrow when I give a modified version of this to the staff, I'll have the computer figured out, the mouse and the microphone, and it'll go smoother for the staff tomorrow. But anyway, again, thanks for coming, and hope you have a great day. Yes?
Can you write into your will, if somebody sues you after you die, that all his stuff goes to somebody else?
I don't know if I follow your question.
Well, can you write into your will, if somebody, after you die,
Yeah.
if somebody sues the estate, and you wrote into the will, he gets nothing if he sues the estate. Is that legal or not?
Yeah. Yeah, you can do that, but some states don't honor those, and you're gonna have a court battle one way or the other. So you can put that in there, but you're still gonna have a will contest probably with whoever is dissatisfied with their share of the inheritance. But yeah, you can put it in a will. Whether it has any effect or not is debatable.
Okay, you spoke about the DNR. In the state of Texas, I believe that there is also an out-of-hospital DNR. The one that the doctor signs that you give to the doctor is applicable in the hospital, but it is not active if EMS comes to your house. You have to have specific DNR, which is an out-of-hospital DNR, which is a separate form. Are you aware of that? I know that you're Colorado, and this is Texas, but you know, we had to do that for my dad, so.
But in any event, the doctor would have to prepare it.
Yes,
Yes.
absolutely.
Right.
But it's a separate form and it has to be on display when the EMS comes in. If they don't see it, you know, they'll do their best to resuscitate you.
So that'd be the perfect place to put it in your file of life, along with copies of these documents we've been talking about today. That's a good idea. I forgot to mention, we all have the vial of life, or we're supposed to. In ours, we have copies of our medical power of attorney and living will, and HIPAA release also. We have those 3 documents. We do not have our financial power of attorney in there because EMT and BAMC medical staff, they have really no need to know anything about our financial status. But it's very helpful if an ambulance shows up, and as you know, if you've been admitted to a hospital, they're going to ask you when you're admitted anyway if you have these documents. They're gonna say, do you have a medical power of attorney? Do you have a living will? And if you don't, by federal law, they give you a little short form, their own documents that you can fill out. So, again, make copies, never give up the original, keep the original in a safe place so it doesn't get destroyed. Yes,
You might wanna keep copies in your glove compartment too.
that's a good idea.
What?
Keep copies in your glove compartment of your car also, in case you're ever in an accident and the police, the EMT have access to that. They know exactly who you are, what your wishes are, and so forth.
Thank you for your presentation, Colonel Crabtree. I want to share an experience that I personally had. My husband has dementia. I have every document that was reviewed this morning, but I found out that that was not enough to deal with his Social Security account. In order to change our mailing address from when I moved from the other side of town here, I had to go to the Social Security office and apply to be a representative payee. You can do that online before you become incompetent. You can appoint people. All you have to do is go in your online Social Security account, fill in the people's names, their relationship to you, and a telephone number. If my husband had done that for me, I have essentially done it for people that I think are going to take care of me. But if you do that, it will save you a trip to the Social Security office, filling out a form, having to consent to a criminal background check, and a very elaborate procedure. It is very important for you to do that. Go to your online Social Security account and appoint that representative payee today. It will save the people who are going to have to help you in the event that you become incompetent. It will save them a huge amount of work. And I'd be happy to talk to anybody about that. I have a lot of experience from my husband having dementia right now. I came here and he's in healthcare right now, but I have spent the last 3 months sorting through documents, sending our durable power of attorney at this last count to 16 different places and for several agencies, including the Defense Accounting and Finance Service, the VA, and Social Security. Durable power of attorney does not have any effect. You must do different procedures in order to manage the account, and all I wanted to do was change our mailing address. Thank you.
Yeah, I'm glad you brought that up. I forgot to mention that when I was talking about power of attorney. There's certain agencies, institutions, for example, that won't accept a power of attorney other than their own form. And the Social Security Agency administration, they're notorious for that. You walk in there with a power of attorney that you just paid some attorney to prepare for you, and clerk says, oh, we can't accept this. We have our own power of attorney form that you need to fill out. Some banks will not accept a power of attorney unless it's on their own form. So just keep that in mind. But an advantage of having your power of attorney, for example, when you walk into Social Security, it may simplify the process of filling out their power of attorney because your agent is right there and can fill out the form as the agent in the Social Security power of attorney form. So just keep that in mind. I had some very upset clients over the years who found out I just prepared a power of attorney form. They went to Social Security and they could not use my form. So keep that in mind. Any other questions this morning? All right, well, thank you everybody for coming. I really appreciate it.